Good morning, everyone, and welcome to a new ForoCompetencia breakfast. We are delighted to have with us Andreas Mundt, who is the president of, as you all know, the president of Bundeskartellamt, and we are going to have Felipe moderating today's event. So I will give the floor to Felipe.
Lo único que nos digo, bueno, díganme ustedes formalmente por correo, que se voy a depositarles y lo hago. En el caso de
Okay. Well, many times it is said that the speaker does not require further introduction because he or she is a well-known person. Sometimes it is true. Other times it is more like a sign of affection or a compliment. In this case, no one would hesitate for a second to declare that Andreas Mundt needs no introduction, and he is one of the most important speakers that ForoCompetencia has had since its creation. I could end here, but I do not want to miss the opportunity for public gratitude to Andreas and the Bundeskartellamt. Andreas has a pivotal role in the international antitrust arena due to his multiple roles. He has been president of the Bundeskartellamt since 2009, a member of the Bureau of the OECD Competition Committee since 2010, and the steering group chair of the ICM since 2013. That's a lot. But perhaps more importantly, Andreas and the German agency have been leaders in an innovative and courageous look at how to exercise authority. And they have always had an attitude of cooperation with the rest of the agencies of developing countries. Andreas, it is an honor to have you here in ForoCompetencia. And let's move to the housekeeping rules. Andreas will be delivering us a lecture on around approximately 30 minutes, and then we will open the floor to questions. So Andreas, you can go ahead.
Yeah, Felipe, well, many thanks for your very kind word. I must say it's my honor, my pleasure to be with you in South America this morning, around breakfast time, as far as I know, in your countries. Here we're heading towards the afternoon tea or the afternoon coffee, but it's a great pleasure for me to join you today. What I would like to do is to give you a bit of an overview what is going on here in Germany in all areas of competition law. You will see I always come back a little bit to the digital economy because that is of very great importance still for us here in the Bundeskartellamt. But I will also touch on the question of cartels, mergers, a new competition tool that we are just about to get here in Bonn, which includes even the divestment, the breakup of companies, only if we find that competition is not working in a certain field and where we do not need an infringement of competition law anymore, which is quite new, at least for Germany. And I will also touch a little bit on the question of how we tackle inflation or how we can contribute as competition agency to tackle inflation. Because if we listen carefully to policymakers here in Europe, you get the impression that it is not the central banks anymore that are in charge of fighting inflation, but it's the competition agencies who are in charge, which from my perception is not completely right. Let's put it this way, although maybe we are able to contribute a little bit. So I would very much like to start with the first point, that is the digital economy and what is happening in this sense, by the way, not only here in Bonn, in Germany, but also in Brussels at the European level. Where we have started in Germany, we have started very early on with doing a lot of work on the digital economy. That dates back 10 years ago, 2013, when we have set up our first internal think tank. We had two roads to elaborate on how we could get the digital economy properly and include it into our work from an intellectual or theoretical point of view, but also to do cases in order to make sure that we were thinking of in theory also worked in practice. And I think that was a very straightforward that we took by that time, and which led already in 2017 to a first fundamental amendment of German competition law, which was, well, it was about including the right vocabulary with regard to the digital economy into law. So since 2017 already, you find words like multi-homing in the German competition law when it comes to the assessment of dominance. You find words like network effects. You see a provision that says even if the consumer is charged nothing, it is still a market in the sense of competition law. Helpful clarifications by that time, I must say. We did not discuss that anymore with our courts, but that goes already back to 2017, and maybe the most important change that we saw in 2017 was a provision that said that data is a key pillar of market dominance in the digital economy. So you see, that is 6 years ago only. Today, it feels like history to me, but by that time in 2017, it seemed very modern, and it was very much, it was very early on. Since 2017, there were 4 years that went on without any significant amendment to German competition law with regard to the digital economy. And that's changed in 2021, and that was very, very decisive, because in 2021, we introduced a new provision in the German Competition Act, a new rule on abuse control, the famous, at least in Germany, in Europe, it is famous provision 19a, which is, as far as I know, worldwide the only specific competition provision that is dealing with the digital economy. It is not regulation. It is still deeply rooted in competition law. It is still competition law, and it follows a two-step approach. The first step that we need to take under Section 19a is to take a decision that a certain company falls under Section 19a, that it is an addressee of Section 19a, and that is for undertakings that are of paramount significance for competition across markets. That is the exact formulation that we have in the German law. This is the way how we describe a digital ecosystem that is subject to these specific obligations in Section 19a. Once we have done this, we can prohibit certain conduct to the companies that fall under Section 19a. Just to give you a few examples, one is self-preferencing of the services of a certain group. Another one is penetration of non-dominated markets by way of anti-competitive means. That is mostly tying and bundling. That is raising or creating barriers to market entry by processing data relevant for competition. We can grant access to data on the basis of this provision. So you see, in fact, it contains everything that you also find at the European level with the Digital Markets Act, the DMA, but it's formulated different, it's more open, and it is, in fact, competition law and not regulation. So what have we done with this in practice? Even more important. The provision is important, but what do you do to enforce it, to put it into practice? Well, as of today, we have designated Google, Meta, Amazon, and Apple as being addressees of Section 19A. Google and Meta are final. We came to a settlement here with these two companies. Apple and Amazon have challenged our decision that they are addressees of Section 19A, and that is pending before the Federal Court of Justice here in Karlsruhe. And since March 2023, we have an ongoing proceeding also against Microsoft, that Microsoft is subject to Section 19A. We haven't stopped here. We have lots of proceedings here at the Bundeskartellamt about the conduct of these companies. Against Google alone, there are 4 proceedings pending in a way. One has been concluded. The one that is concluded was on the Google News showcase, where we have come to significant improvements for publishers with regard to remuneration by Google if they make use of the product of the publishers. We are looking at the data processing of Google, if this is in line with competition law. We are looking at Google Maps, if everything that Google is doing here is in line with competition law. We're looking also at, well, the car infotainment that Google is providing to car manufacturers. We have an ongoing proceeding against the app tracking transparency initiative of Apple. We are looking at Amazon in a twofold manner. We have one proceeding ongoing that is looking at the question if Amazon is controlling on the Amazon marketplace the price that the merchants on the marketplace are calling up. And we look at the question if, well, if Amazon does some brand gating, meaning that it protects brands from other companies who want to sell these brands on Amazon, maybe also in order to raise the price. So you see, all in all, these are lots of proceedings, even for a relatively big authority like the Bundeskartellamt. This is really a lot, and you can imagine that it is not so easy against these big companies with the small staff that we have over here in Bonn. What is ongoing, by the way, is I call it the mother of all digital cases. That is our Facebook case that we have decided back in 2019, where we have said that Facebook is not allowed to combine all the data they gather on Facebook, on Instagram, on WhatsApp, and on third-party websites if the user does not agree to the collection of this data, because we believe that data is key for the dominant position of Facebook. And what is key in that is the variety of data that Facebook is collecting. If you want to make use of Facebook, Instagram, or whatever, you have to give your consent as a user to the limitless use of your data, the limitless use. And we have said, even if the user does not give a consent to this limitless use, he is still allowed to use Facebook. So that was new about the case. And what was also new is that we assessed the way that Facebook is gathering the data. We did that on the basis of the European GDPR in connection with the privacy authorities, the data protection authorities that we have here. And just last week, it happened that the European Court of Justice said that we as a competition agency are allowed to assess privacy rules in order to assess the data-driven dominance of a certain company. That was quite a ruling by the European Court of Justice for us as competition agencies, but also, of course, for data protection agencies, because it has clarified lots of things about this issue of privacy in this matter. So we will also proceed now with this Facebook case before the courts, and we will see where it takes us. So you might wonder, how does all that fit into the European regulatory framework that we have, the Digital Markets Act, the DMA? Well, the DMA is regulation. The DMA is more narrow than Section 19A because it's only meant to be of value for specific companies, so-called gatekeepers, only for certain services, that is core platform services. These are services that you need as a business to reach out to the consumer. And thirdly, the DMA contains an exclusive and exhaustive list of do's and don'ts. So you can easily see where is there room for Section 19A. It's very easy. We can act if we have a service before our eyes that is not a core platform service. And we are, of course, now anxious to see what will be designated as a core platform service by the European Commission. And what is even more important, if we look at a conduct that is not caught by the DMA because it is not in this exhaustive list of do's and don'ts, we come in again. So we have room for the application of Section 19A, and thus we make sure that we have no parallel investigation and proceedings in Brussels and in Bonn. And I believe that Section 19A, besides the DMA, maybe has a great future, because what is very important, think of the fact that the DMA contains an exhaustive list of do's and don'ts. So what happens if one of these companies that might be designated to be addressee of the DMA is developing a new conduct, or if they find means to circumvent a certain conduct that is listed in the DMA, again, the Bundeskartellamt comes in and can take up this conduct. So I think it's fair to say that I believe we will have also in the future have many proceedings with regard to Section 19A. And now it gets all the more interesting when we talk about artificial intelligence, because artificial intelligence is a little bit, at least generative artificial intelligence is kind of new. It allows for a new conduct of big tech. And I think it will make everything much worse, because I personally believe that it will be mostly big tech that will benefit from artificial intelligence. It's very easy. What do you need to make use of AI, of artificial intelligence? You need the computational capabilities. Who has that? The big ones. You need the financial resources. It is said that Microsoft has spent millions of dollars to implement ChatGPT into Bing, millions of dollars. So you need lots of financial resources. You need a cloud in order to make best use of it. Who is driving clouds? Again, we talk about Microsoft, Google, and Amazon, and others of the big ones. And last but not least, what you need most of all is data. And who has the data? Who is able to crawl all the data in the internet? No need to say again, this is the big ones I'm talking about, who get all data, huge volume in real time, as fast as possible, to the greatest variety. Again, we talk about Google, Apple, Facebook, Microsoft, Amazon. So it makes all sense in the world, I think, that we focus so much on the digital economy, and we will continue to do so, although I must say, with the scarce resources that we have against all the resources that the big ones have, it is not an easy task. Of course, we also care about the so-called bread and butter topics. For example, we care a lot about cartel prosecution. That remains most important for us as the Bundeskartellamt. We had a significant decline in cartel detection and dawn rates. That was due to the COVID period. Over here, it was very difficult during that time to do dawn rates and all this. We were not happy with the development of leniency applications over here. Leniency applications are still most important for us as an agency to detect cartels. You should know that 50% of all the cartels that we reveal, that these proceedings go back to leniency applications. If you look at the figures, that is a bit worrisome. In 2015, we had 76 leniency applications. In 2022, we only had 13, so there has been a very sharp decline. It is a worldwide trend, I know that. Over here in Europe, and I must say, we do not do that on our own. We do that together also with the European Commission and our sister authorities here in Europe. We're looking for the reasons for that decline of leniency, especially here in Europe. I think one key reason is the EU directive on antitrust damages actions that we have set up here in 2017. It affects the liability of immunity recipient. There is no cartel in Europe after which you do not see follow-on damage claims. And of course, the leniency applicants, they are not released from their liability here. So I think we have a good reason, again, to look at this damages directive and in how far we need to do some changes in order to increase again the number of leniency applications. I'm afraid that is not the only reasons. One reason might be that companies have stepped up their compliance efforts over time. What we also see is an increasing complexity of leniency applications, for example, with regard to international cartels, that might deter the one or other to come into an agency for leniency. So what does it take? I think we must increase the probability of detection by other means also. And it will not be done by just looking at the damages directive. We look at other means to detect cartel. One instrument that is extremely helpful is that we have an anonymous digital whistleblowing system. You can get into contact with the Bundeskartellamt and report a cartel. We do not know your identity, but you know ours. You can talk to us, we can communicate, but we have set up measures that we have no idea who is talking to us. So that is very welcome, of course, for those who want to come in for leniency as a first contact point. But this is also very helpful for those outside a cartel who just have this feeling there could be a cartel, who have indications that there could be a cartel, so-called whistleblowers. Another means that we do work on is IT-based screening methods. That is successful in some cases. We just recently had some cases that go back to such screening methods, and in the very helpful, by the way, with regard to bid rigging. So I hope that this mix of instruments, improved leniency, whistleblower systems, plus the screening of markets will help us in that way. Third issue I would like to touch upon is mergers. Traditionally, the Bundeskartellamt assesses many mergers every year. In 2021, it was 1,025 mergers that we have looked at. Even for an efficient agency like ours, this is quite a lot. We have raised the notification thresholds then. So in 2022, we had only 834 mergers. I think we can deal very well with that. I think for the time being, the assessment of digital mergers also plays a key role for the time being. From both perspective, from a formal point of view and from a substantive point of view. We all know about these killer acquisitions of potential competitors. That is the formal point of view. How do we make sure that we can assess mergers where we have maybe a low threshold, a low turnover, but for which a high price is paid given the competitive potential of these companies? We have chosen to introduce a new threshold here in Germany, the so-called transaction value threshold, that accounts for the transaction value of 400 million euros. There are some more thresholds, but that is the key threshold. So if one company pays for the target more than 400 million euros, we can look at it, even if the turnover thresholds are very low. So that is one part. The other part is, of course, are we able to assess these digital mergers in a proper way? I think today we're all aware there have been mergers in the past that maybe we should not have cleared. If you think of Facebook, WhatsApp, Facebook, Instagram, Google DoubleClick for me is a very important case in this sense. We see that sometimes we see digital mergers where it is very, very difficult to prove that you have a substantial lessening of competition, that you have a substantial impediment of effective competition, because the effects of the mergers will only be seen over a long time. But it is very clear that this merger might strengthen a digital ecosystem. We have seen such a case, Meta, who has bought a company called Customer, which was also scrutinized by the European Union, and we saw much of problems to block that merger, although we saw that given all the strategic plans of Meta, Customer was a very important puzzle piece in that strategy, but it would not harm competition in the short and in the middle run. So these are things we should look at, and here again we are thinking about an amendment in Germany. If, for example, if we should introduce a new criteria for blocking a merger, a new theory of harm that is like strengthening an ecosystem, strengthening a company that is of paramount significance for competition across markets. We are about to introduce a new amendment of the German Competition Act. The new tool already has a name. It is called the new competition tool. You know that maybe from the European debate that we have heard over times. The new competition tool means that in the future, and this law, this amendment has just passed Parliament last week, so this is still very much discussed. It's not yet in place, but it will be in place in due time. The new competition tool works as follows. It all starts with a sector inquiry that we can do. If we have done this sector inquiry and we have found a significant and continuous or repeated malfunctioning of competition, we will be able to adopt all necessary behavioral or structural remedies that are necessary to terminate or mitigate the malfunctioning of competition. without the need to prove a specific infringement of competition law. In a way, this is really new for German competition law, because we do not need an infringement, we don't need an agreement, we do not need a misuse, an abuse of dominance. All we need is a sector inquiry, and then we need this decision that we have a malfunctioning, and then we can do anything that is necessary, including structural remedies and including as ultima ratio even the divestment of company shares or company assets. So you see, this is quite far-reaching, well, we will see how to work with that. We all know there are markets where you do not have competition anymore. That can happen by the internal growth of a company. That can happen by the fact that a company grows by mergers beyond or below the radar of merger control. We all have these markets in many countries. I think if you stand before exactly that situation, it can be good to have this tool, this new competition tool at hand. It is, for us, a very difficult tool, because to the companies that are subject to such a proceeding, it offers lots of opportunities to go to court. At the first time, they can go to court after the sector inquiry, when we have taken the decision that a certain market is not functioning well in terms of competition. That is a decision that we have to take, that can be appealed by the companies that are affected. Then we have to wait for a decision of the court. And once we have a positive decision of the court that we are right and that we haven't done any mistake, then we can take the necessary measures. And here again, the companies can go to court, of course. So you see, there are lots of opportunities to go to court. Court proceedings are lengthy. Our own proceedings, because we have to be very, very thorough, are lengthy too. So we will see. How we are going to work with that. It's a lot of responsibility in our hands. We are very much aware of this. But again, I think it can be a useful tool in certain markets. My best example for where this could be useful, of course, everyone asks me now in Germany, what is the first market that you're going to look at? I always refer to the UK and to the Competition Commission, who by the time divested the airports in London and other airports, Heathrow, Stansted, and Gatwick. That is a good example for that tool, and I'm very happy that I do not have to name yet any markets in Germany that we want to look at with this tool. Again, it is very new. The Parliament has just taken its decision. It will come into force this fall, and then we will see how we are going to deal with that. By the way, the next amendment of our law is already on the horizon. There are plans that we should have something on sustainability cooperations in the law. I'm not sure that this is really necessary, but this is the plan. And maybe we get some competencies with regard to consumer protection, we will see. So this leads me to my last point, just briefly. Inflation. How do we deal with inflation? The Russian attack on Ukraine has sent many markets in Europe into a turmoil. Inflation is everywhere, especially in energy prices and especially in food. So especially in these fields that affect many consumers in Germany and that are of utmost importance. We have aligned our focus in a way a little bit to that. What we had and what we have looked at are, for example, crisis-related cooperations in the economy. We try to accompany these cooperations in order to give the companies kind of a legal certainty that if they cooperate during the crisis, that they don't get a fine in the very end. But of course, we also have to make sure, and I think this is probably the same in every country that is fighting with inflation, that we are not a price control authority, but that we are authority that should reinstall competition and take care that competition takes place in order to take care that we have low prices. Beyond that, we do what we can do. We do monitoring. For example, in the fuel market, immediately after the war, we have set up a sector inquiry on fuel, especially at the refinery level, because we have seen an explosion of the margins at the refinery level. We have seen that the price for fuel or for oil, for crude oil, did not increase in the same way. So there was a gap in a way, and we wanted to know who's making the money here and why is this happening. So monitoring is very important. We also monitor the prices at the petrol stations. In Germany already for a long time, we have a market transparency scheme for petrol prices. We get the price at every petrol station in Germany. We have around about 15,000 petrol stations in real time. And we pass on these prices to apps on the smartphone so that the car driver can compare prices immediately on his mobile phone via an app. But of course, we have the prices then, and we can monitor them, which is very helpful in this situation. And we constantly report to the public about the development of prices. When we look at the food retail sector, here also we see price increases sometimes that we do not understand. Then we ask the producers, retailers, what is going on, and we want to get an explanation. And last but not least, I think we have all good reason to be very vigilant in these times about price increases, very vigilant if there are maybe agreements, if there is collusion with regard to price increases. And we do our utmost to keep pace here with the economy and to take care that if the prices rise, that is not because there has been a cartel agreement. Yeah, Felipe, this is my overview, so to say, that is moving the Bundeskartellamt, if you want to put it this way. There are many more issues, of course, like always, but I think that goes a little bit to the core of what we are doing over here and in Germany, and what is of the biggest and greatest importance for the time being. Many thanks.
Thank you, Andreas. A very interesting presentation. So now let's move to questions. I would ask you to be very precise because I assuming that there are coming many questions. So I probably will take 2 to 3 questions in a row, and then we will move to Andreas. So please raise your hands. Juan Cristóbal, go ahead.
Thank you, Felipe. Thank you very much, Andreas. Very interesting presentation. Andreas, how are you seeing this kind of overlap of regulations concerning merger control, in the sense that on top of merger control now you're having in many jurisdictions foreign direct investment filings, and now it is coming a foreign subsidies regulation. How these 3 type of filings that I understand are being reviewed by different authorities are going to interplay, and how much tougher will be to get through these 3 types of filings to get a merger approved?
Good, excellent. So let's move to Juan Pablo Iglesias.
Thank you, Felipe. A question for Andreas. You mentioned some of the very fascinating and complex digital cases that the Bundeskartellamt is currently examining, but you also mentioned the agency's small staff. in terms of employees. So my question is how this small staff is able to handle these cases, and if whether an essential part of that team consists of tech experts as data scientists or IT engineers.
Yeah.
Good. And we will finish with Herman, and then we will ask Andreas to answer those questions. Herman?
Yeah, thank you very much. Yeah, I have a question regarding Facebook case. So basically, the European Court of Justice is stated that so it may be necessary for the competition authority also to examine whether the undertaking's conduct complies with rules other than those related to competition law, such as the rules laid down by the GDPR. So my understanding is that this is not only related to data protection regulation, but some kind of any kind of regulation now can be considered by the competition authority in the assessment. My question is whether you have the same interpretation of that decision in this regard, and if yes, do you think that after this decision, then, for example, environmental regulation should also start to be considered in the competition law investigations and enforcement? And of course, if the Bundeskartellamt has some vision in this regard.
Thank you, Herman. Andreas, I don't know if you want to take those questions.
Yeah, sure. Well, with regard to the first question, indeed, in the past we were alone. There was one agency that was looking at the merger, and that was it. We do, for example, foreign direct investment investigations over here in Germany already for a long time. That has been increasing over the last years. An assessment that is not done by the Bundeskartellamt, but by the Federal Ministry of Economics. So you have parallel proceedings. I must say, we have very little contact with the ministry because we think everyone should do his or her job. And it is our job to look at it from a competition perspective, and it is the job of the ministry to look at it from a very political perspective. And that does not necessarily go hand in hand. And that happens that we have diverging outcomes in these proceedings. And I'm afraid a little bit, to a certain extent, this is what we have to live with in the future, that we have more of these investigations and that we have more of these situations. What I find important for Europe is that not every country does this job along his own criteria. And this is what the European Commission is working on. And by the way, competition agencies will be included into that, which is maybe meaningful in a way that they might do some investigation in this respect or so. But I'm not saying I'm seeing this critical. I know this is an additional burden for companies. This is so. But again, I think this is nothing that we can help, and it is going to increase in the future. We will do some work on this, by the way, in the ICN, because we have identified it as a problem and that we should take a look at it. And we will hold a webinar or something on this issue in the near future. It is something that deserves a closer investigation. But as I said, it will not help very much. This is a situation that will get even worse. Juan Pablo, yeah, the small staff. I think we will always struggle with lacking resources. That is so. If you look at the Bundeskartellamt, which is in an international scale, it is quite big. We have something like 400 staff here, but we do not have 400 for competition. We have people in these 400. There are people who do things in the so-called competition register. We have people who do public procurement. There are IT people. there are other areas. So if you look at a certain case that we are doing, in the digital economy, you have 2, maybe 3 people as a core of the team, and that is added by IT people, by economists from the general policy unit, by lawyers from the legal department. So I would say, I would call that it is breathing in a way. It depends very much on the question at which phase is this case and what do we need to do about it. But of course, this is not enough. I mean, if you go to court, I do not need to describe that. You know that very well from Latin America, and I'm pretty sure we show up with 4 people, and on the other side, you find 12 or 13 and partners from the biggest law firms that you find in the world. That is something we have to deal with. It's fine. We have dealt with it very well in the past. We had lots of wins before court, be it the Federal Supreme Court, be it the European Court of Justice. But that's the way it is. And personally, I must say, I have always been a friend of much responsibility on few shoulders, because that gives the people a lot of intrinsic motivation. It is their case. And if they don't do it, nobody's going to do it, you know? And I think this is quite motivating for my staff. But of course, on the other hand, you must see it can become too much. And if you cannot handle it anymore, things get difficult. And for example, if I look at papers that receive today from companies, it can be very, very difficult already just to separate the noise from the substance. Sometimes we wonder if we do not need AI for that in the future. If you receive hundreds of pages, sometimes thousands of pages, and well, you have to find out on your behalf what matters, what is important, and what you can leave aside. That is in itself already sometimes a difficult task. So yes, we need more staff in order to handle this, like most of us. We will see how the European Commission will get along with 60 additional staff to handle the Digital Markets Act. We'll see if that works and how well that works, but I agree it is a problem. So back to the Facebook case. In fact, the third question, the European Court of Justice has fully confirmed what we have said in this case. And what was it that we have said? It was that if the dominance of Facebook is data-driven, we must be able to look at this question, this most important question, is the gathering and processing of the data justified, and is it in line with the law? And if you want to look at this question, you need a parameter, you need a criteria. So you have 2 options then. One option is you can develop your own criteria, something like a data or a competition conform processing and gathering of data. I'm not sure if this would make sense, and that was not our choice. We said if we need to look at the data, and if it is processed and gathered in a way that is in line with the law, we take the law that already exists and that Parliament has decided upon, and that is GDPR. It's as easy as that. And in fact, the European Court of Justice has confirmed exactly this argumentation by adding that, of course, we are no specialists in GDPR. There are other authorities who know much more about privacy, and they have told us you are obliged to cooperate with these agencies. So we can do our work, but we have to consult, we have to coordinate with the national or maybe European privacy authorities and data protection agencies. What we have done in the Facebook case, that also has been confirmed by the European Court of Justice. And I think this is very, very important for the future. If that is scalable to other areas of law, I'm not so sure. Sustainability is always the big elephant in the room for the time being. Again, here you can say we are no sustainability environment law people, but of course, sometimes we have to look at environmental issues. We are not driving that forward, but we need to react because companies come into the Bundeskartellamt and say, listen, we want to do this and we want to do that. We want to cooperate in that way in order to foster, in order to enhance sustainability, but it might be at the same time an infringement of competition law, and we have to look at it, you know. So it is not that we are driving this question, but we need to react, and this is very important. We are struggling with that. We are finding our way. We have lots of cases where we have said, yes, this is in line with competition law. We solve these cases on the basis of the discretion of the Bundeskartellamt not to intervene. This is the way how we handle it for the time being. But of course, I fully agree with you. This question is on the table, and there's also the question on the table if the lawmaker is going to react to that and saying that if you apply competition law, you have to take into account environmental issues. And my last word on that, which is dangerous in a way, because environmental issues are obviously not competition issues. And I'm always a bit afraid that if you open the law in this sense towards environmental issues, other policy issues might slip into the law over time, like social issues, public interest issues, and then very fast you are in a sphere of a very politicized competition law, and this is where I do not want to get. So the question is very, very critical.
Thank you, Andreas. Leo Peralta.
Hi, good morning, good afternoon. I have a question for Mr. Mundt. I understand that among the provisions approved by German Parliament this month, there is one which allows the authority, the Bundeskartellamt, to a period of 3 years after the closing of an inquiry to notify transactions on a concerned sector if their findings are. And there are findings which concern the authority. I wanted to know a little bit more about this provision, and if that means that even, for example, merger and acquisitions made during this period could be subject of this new provision, and if in an extreme case there could be subject to an unwind of a dismantling of this transaction. That would be my question. Thank you.
Thank you, Leo. Ricardo.
Nice seeing you again, Andreas. One question, I mean, you were talking about the damages directive of the EU as a possible cause of the fewer leniency applications you're receiving. Are you thinking specifically about certain changes that may be introduced to this directive, for example, like making that the first applicant is not subject to damages, to compensation of damages, unless the other cartelists are not able to pay the damages, like a subsidiary damage obligation or something like that?
Thank you, Ricardo. And now let's move to Sebastián.
Thank you, Felipe. And thank you, Mr. Andreas. I wanted to ask you if you have an advice for a young competition agency in a developing country to address the digital problems of competition law, specifically considering that maybe the strength that agencies have here is not as compelling comparing to European Union mechanisms. If you could
excellent.
Explain
Andreas?
something.
Good. Thank you, Sebastián. Andreas?
Yeah, Felipe, very many thanks. Yes, indeed, there is also a new provision on mergers in this law that Parliament has passed last week. which says in a nutshell that if there are severe competition concerns in a certain market with regard to a certain company, we can oblige that company to file any merger in the critical market in the future. I think this can be a very important provision in the future, because we have markets where we see lots of concentration triggered by one company. And we see an ongoing concentration process in these markets because these companies, they continue to buy new targets again and again and again it's all below the threshold of merger control, by the way, very important. And then one day you wake up and you have a completely concentrated market before your eyes because you couldn't take a look at it. We have already a provision in the law that allows for that now. That will be improved now by the law that has been passed last week. It's important to know that also before we oblige a company to file every merger, we need to do a sector inquiry. So we cannot do that without gaining very much knowledge about it, and then we can do it for a couple of years. It can be renewed after a couple of years. We haven't done it before, so we will see how we make that operational. This new provision. But here I'm deeply convinced that this can really help in some markets where maybe also regional markets or smaller markets, in order to make sure that this market is not getting further concentrated. That can be very important. Again, we haven't made use of it yet, and we will take a close look at this now. Yeah, second question, Ricardo, great to see you today. Very happy you're with us. Yeah, indeed. We think about changes of the damages directive together with the European Commission, which is really not an easy task. Because it cannot just be as simple as saying, well, the first immunity applicant who comes in is not liable for damages. Why is this not the way forward? Because we also need number one, number two, number three who comes in order to prove a cartel before court, which means we cannot shift just all the damage to those who come in later. That would be too easy. So we must think about lots of things. The external liability vis-a-vis the victim of the cartel plays a big role. But what plays maybe even the bigger role is the internal exchange between the cartelists and who has to bear which part of the damage. I think that is even more important, and that makes it very, very complex, because you can think of lots of things, how you can balance that. Maybe you can include the contribution to the detection of the cartel, or the contribution to the enlightening of the cartel for the agency. So lots of models are thinkable here, and this is why it is not an easy task. What is necessary to say, we cannot do that on our own behalf alone, because again, this is a European directive. We have looked at the question if we could do changes by changing the German law. I do not think this is sufficient. So in the very end, it will need a solution at the European level. But I think I can also say this is going to be a long process, because there are lots of interests involved here. But we have a fierce debate that is going on, and we will see about the outcome. But it is extremely complex, because it is not as easy as I said, well, let's get the first one out of it. That's not the way forward. We can be very sure. Yeah, Sebastian, with regard to your question on how to, if I got it right, it's how to address problems in smaller agencies, so to say, in developing countries. I mean, I recommend what I always recommend, and what I also recommend to my people. Take a close look at how others do it, and then try to make it fit for you, for your agency, for your proceedings, for your legal framework, for your economic framework, because it is very difficult to copy something, you know. I mean, I think international organizations come into play. There are lots of papers by the International Competition Network, by the OECD, what about just to give you an example on theories of harm. What can be theories of harm in this context? There are lots of papers how to tackle these theories of harm, about the remedies that you can take if you want to tackle these theories of harm. And I always recommend to take a close look at this, and then maybe trying to take a decision how to tackle it. And if you look at, well, kind of homogeneous areas like from Europe, Latin America always looks very homogeneous. You know better about that than me, but it looks like. And I think it would be an excellent idea to discuss that, for example, in a regional forum, to say, how could we best do it? Because you will be best if you do it together. That's for sure. And if you have a joint approach, in a way, you know, it must not be completely in parallel, that's not the point, but if you have a common understanding, and I think this is the way how I would look at it. All over my professional career, I always said to myself, everything in life starts with a good copy. And then you can develop your own proceedings and thoughts and everything, you know, but first of all, look at how others do it, and I must make this a bit more relative. It's not really a copy, but it's looking at how others proceed, and then they take a decision. Is this something for me? One size never fits all, but it could be a good start to get a smell how others proceed.
Thank you, Andreas. Very interesting. And I think we have to stop here. And again, Andreas and Barbara, it has been a privilege to have you here and answering our question. Julian?
I don't know if Andreas, you have time for a tradition here is that the guest speaker gives his final conclusions and final words on before ending the event. I know we are abusing of your time.
Yeah, I must say it's really a great honor to be here in this great forum. I mean, we have lots of contacts among us, and at least the heads of agency from the Latin America competition agencies. I'm very happy that Latin America is so engaged also in the international competition network. That is of great help, and I'm always thankful for the support that we get in these international fora from people like Ricardo, from Felipe. I mean, how often have we met? And it was always great to have that kind of exchange. And you can always be very sure we always try to learn from each other. And this is not a one-way street. That is really not a one-way street. When you go to a conference, sometimes you go back and say, well, in fact, I did not learn very much new. But sometimes you go back and you never know where this is going to happen. And you think, very good, I was there. And you bring home new ideas. And I always get great ideas from Latin America from time to time. And I only hope from time to time it's also the other way around. So many thanks for having me. It was a great time, and many thanks for your questions also.
Well, thank you very much, Andreas. Thank you, Felipe, also for moderating. And I will invite you to join us. The next breakfast will be on August 24, and we will have Professor Ariel Strachey from Oxford University talking about AI and antitrust. So it will be a good continuity to the issues raised by Andreas. Thank you very much.
Great topic. Many thanks. All the best to you. And again,
Bye.
Thank you so much.
Bye,
Excellent.
Thank you. Bye-bye.
Thank you very much.
Thank you. Bye-bye.